name is Monica Fry, and I'm the Vice Chair of the Professionalism Committee. Why can't I say that? And it's my honor to introduce our speaker. And before I say that, we want to thank our attendees online as well as everybody that came into the room today to meet in person. Let's see, introduction. We are introducing Jonathan Kopecky. Mr. Kopecky received his Juris Doctorate from the St. Louis University School of Law in 1998. He has been licensed to practice law in both Iowa and Minnesota since 1999. Mr. Kopecky practiced real estate law for 5 years while an associate at Ackley, Kopecky and Pingery, LLP, and then practiced canon law for the Archdiocese of St. Paul and Minneapolis for 8 years. Mr. Kopecky is currently in-house counsel for the Director of Professional Standards for the Minnesota Association of REALTORS. Welcome.
Thank you. All right, this is good. I need to know the latitude I have to walk because I'm a wanderer. All right, well, morning everybody. Good to see you. For those of you that are online, we were discussing Wordle today. I got it at 5, which is actually really good for me. So I know we're really close to the end there, but it was, yeah, anyway, got it. So we're just going to talk a little bit today about what we're seeing. Some of it's statistics. I apologize. Nobody loves statistics. It's not the most fun thing, but it's also good to see where we are kind of year over year and what's happening. So we're going to go over that. And we're going to go over kind of the hot button issues that we're seeing. One of the fun things about each market, no matter what it is, there's always things that are being innovated in a good way about how we can help our clients and some lines that are getting pushed in a bad way about code of ethics and things like that. So we're going to kind of see what's going on there. So one of the things I wanted to start with was an ombudsman. A lot of people don't even know that we have one, but we do have an ombuds on staff. And I think it's important just to kind of know what an ombuds does. So I don't really know the origin of the word. It's a strange word. Everyone calls and says, I need to talk to that Budweiser person. And I say, yes, I wish we had that, but we don't have a Budweiser person exactly. But the ombuds person is a person who is really there to help kind of mediate problems that are coming up. Right, that's the idea. Although officially they're not a mediator, they're really somebody who is there to try to get people to resolve issues before we get to the point of having to file a code of ethics complaint. So people often call our ombuds and say, I'm having a problem with my broker. How do I fix this? What can I do? I want to file a complaint. And they'll say, well, let's talk and see if we can talk to them first, see if we can address the issues that you're having trouble with. Okay. So last year we had 28 people contact our ombuds about complaints that they had. 23 of them were resolved without having to file a complaint. So that was an additional 23 complaints that we probably would have had that didn't happen. And so that's pretty good. We did have 2 that subsequently filed. And of course, we have a few that just say, I don't want to deal with this anymore. Right. So that's a good thing. I mean, it's a positive thing. So what happens when someone initiates the ombuds is we will contact the broker and say, hey, we've got somebody that's got a problem or concern. Are you willing to work out, talk, see if we can work through some things, talk through us. We generally recommend you do that because it kind of means they're headed toward an ethics complaint. If we can head it off before it gets to that point, it's a good thing. And she's been really successful in doing that. So wanted to make sure we were aware of that program exists and it's available for anybody. Even members could call and say, I'm having a problem with another member. That's something that could be done. But kind of more often than not, it's a member of the public who's got an issue and we're trying to head it off. Now, we had a banner year last year. In terms of complaints, we had over 150 complaints that were filed for us, 150 issues that we've dealt with. So that's quite a bit, more than we had over the past few years. Why? I don't know. I mean, I don't have a good sense of that necessarily. I mean, it's an interesting market. We've had some interesting things happen in the market. We've had a lot of people who just felt like no matter what, they can't get a house. You know, they keep trying, they keep putting offers in. Sometimes they have very good reasons for filing a complaint. Sometimes they have frustrated reasons for filing a complaint. But it is, it's getting better. Now, in terms of arbitrations, this is just commission dispute arbitrations. This is not buyer-seller arbitration. That's a totally separate thing from us. But commission dispute arbitrations, procuring cause arbitrations, we had 13 requests last year, which is down a little bit. We've been kind of consistently down. I think this is really positive, right? Ultimately, this means brokers are picking up the phone and saying, hey, we've got an issue. Let's see if we can work something out. And they generally do. From those filings, we only had 5 hearings that were held, which again means, hey, I filed, let's see if we can work something out. And generally things got worked out. And when they didn't, we had to have hearings, and those hearings occurred, and we made decisions for people. In terms of the complaints we received ethics wise, 137 complaints, 31 were dismissed by the grievance review because they just didn't have a real complaint to make. 65 of those actually went to hearing. So year to year, you can just see our filings are up, right? We're on pace this year to match this right now. We're not going to exceed this, but right now we're on pace to match this. So you can see complaints are up, hearings are up over the last few years.
Jonathan, somebody in the chat section suggested that maybe it's because of an increase in agents. Do you think that has anything to do with it along with market?
It's a good question. Maybe. People often ask that. Is it newer agents? Is it just newer agents? It's not. We definitely have our share of newer agent issues. That does come up. But I wouldn't say that even 20% are newer agents where it's like they just don't know what they're doing. It's disturbing. If you sit on the panel sometimes, you'll see people that have been in the business 10, 12 years and they go, well, I've always done it this way. And you're like, wow. Oh, really? Because wow, that means there's been a whole lot of problems that are going on. So that's some of it. I mean, we do have more agents and that's positive generally, but we have also a lot of good brokers, quite honestly. We have some, I shouldn't put it that way. We have some very good brokers who really take their agents under their wings and say, I want to teach you the business. We don't have problems with those people. We never have had problems with people. We do have brokers who go, I'll take you on, and they don't give them any advice, don't give them any direction. And that does create problems, and that always will create problems. So we know that that's a problem, but mostly, no, it's not necessarily the new agents, particularly, although we do get our share.
And she did want to clarify, she was meaning more agents equals more complaints.
Oh, sorry. I mean, that's possible, just in terms of volume, possibly. Yeah. Now, I know everybody in here and everybody online knows by heart the articles of the Code of Ethics, and so I don't need to explain these. But I always think it's important just for my own education to kind of talk about it. So if you just look at it, it's really hard to read these. I'm going to point them out to you where I can. But the big tall one here, this big tall one is Article 1. And Article 1 is that duty to protect and promote the interests of our clients and to be honest to all parties to a transaction, right? So that's where we get almost all complaints, that almost all of them touch that to a degree. And that's why there's so many more complaints about Article 1 and so many more filings about Article 1. But it doesn't necessarily mean that they're found in violation. So the big blue line means the number of alleged, this is the total number of alleged. These are the ones that are found not in violation. Those are the ones that are found in violation. So remember, in our process, you have to find a violation with clear, strong, convincing evidence. So we need to know that a complaint is proved, right? The panel needs to be convinced, yep, okay, this happened, this was wrong, this is a violation. So all of these allegations are almost always times made, but doesn't necessarily mean they're proven. Our process requires that proof. So Article 1 is the big one there. And then Article 2, that is our duty to make sure that we are not exaggerating, misrepresenting, or concealing pertinent facts about a transaction or a property, right? So that's basically our disclosure issues, right? Those are always going to be a question. We're seeing more of those already this year, and I think it's because of the market, right? We're dealing with a market where we didn't do inspections, right? I mean, we just didn't. We had buyers who were making offers. We were saying, let's make it as clean as possible. We might have an inspection, but we're not going to make it contingent on inspection, or maybe we're not even going to have an inspection, period, right? We're starting to see that now come back to roost a little bit for us, right? Where we're starting to go, okay, that's an issue. A lot of people are now finding serious problems with the properties they purchased. They didn't know, it wasn't disclosed. Who knew, who didn't know what was going on there? A ton more of the waivers than I ever thought we'd ever see, right? I mean, a lot of people are doing the seller's alternative disclosure waiver, even though they've lived in the home for 15 years. And buyers are accepting it because this is where we are in the market, right? Buyers just have no standing. They got to just accept things as they are. So this is where we're getting lots of challenges now. Article 3, that's our duty to cooperate with each other. Where we see Article 3 issues, mostly that is buyers who are showing up at properties without proper times, you know, and entering properties without proper permission and not following the instructions that they're given in terms of what those showings are supposed to look like. So that's always a problem. I think it's an embarrassing problem. It's what most people complain about. Yeah.
Include like appraisers too, because I've had appraisers show up 2 hours before their time.
I wish it did.
Is this just agents?
I wish it did. No. Unless if they're a licensee, yes. If they're a licensee and they're a member, yeah, then definitely we can. Right. But it's frustrating, isn't it? Actually, one of my favorite stories was of an inspector, right? So inspectors aren't licensed, they're typically not members. And this person had an inspection, and 2 days later, the inspector came and knocked on the door of this homeowner. And he said, I'm here to pick up my device. And she's like, what device? And he goes, my device. And he walked right past her, like into her house, right? And she's like, what are you doing? Where are you going? He's like, oh, I'm just picking up my device. And he goes up into the bedroom. And she's like, what device? And underneath the bed, he pulls out this big thing that was recording for 2 days. And it was recording the sounds and vibrations because there was a railroad track nearby, and the new homeowner wanted to make sure that he wouldn't be kept awake from it. Just, what is that? He goes, we've just been recording the sounds and vibrations underneath your bed for the last 48 hours. And she was livid, as she had every right to. She filed a complaint, and the agent said, I had no idea he did that. I had no idea the inspector left that. He didn't tell me he was going to do that. My client didn't tell me he was going to do that. I had no idea. There wasn't anybody to bring a complaint against, but it was like, yeah, that would be really awful to think I was being recorded for 2 days. Yeah, so, but yeah, that didn't go very well. I felt bad. All right. Article 9 issues, those are our issues related to making sure everybody gets a copy typically of everything that they're signing, and making sure that the agreements that we're drafting in clear and understandable language. So my favorite of all time was we had an inspection amendment contingency, and it just said fix roof. I mean, truly 2 words, fix roof. That was it. And it was like, yeah, well, you see, there's not a lot of clarity there about what that even means, who's going to do it, when that's supposed to be done, how that's going to be continued on. I mean, really fix roof. You didn't have time to write even a complete sentence out in that. So that one was kind of fun. We're now dealing a little bit more with Article 10s, but even then we're not. We had changes, and I'll cover it if we get a chance to. We had changes to that, about posting things online that were discriminatory, things like that. We still haven't gotten a ton of cases on those, and I think that's positive. That's good. We've had a few that's gone up, but even then it hasn't been tremendous. Article 12, those are advertising issues. We're always having advertising issues. We're seeing a lot, and I'll discuss that a little bit going forward here, where people are putting a lot of things online. They are licensees, but they're not disclosing that they're licensees. We're seeing a lot of people send out what looks like handwritten letters to people on scratch paper. I love your house. I've always been interested in it. Can I buy your house? So-and-so phone number, nothing about they're a licensee, nothing about a brokerage, right? And they just have these devices now that print these out, and people look at them and they think, oh, this is a real thing. This is not a mass mailer that's going out. They've got my name on it, my first name, and they have their signature on it and a phone number. And then they call, and people get very frustrated when they realize that it's, when we talk about the wolves, right? The wolves and the sheep, it feels very much like that. So we're seeing a lot of that. Article 15, that's our, make sure that we treat each other well. We don't recklessly make false or misleading statements about each other to our clients or to potential clients. But don't go with Bob, he's a moron. You don't want to work with him, things like that. We're seeing a few more of those. Article 16 is our anti-poaching article, which is to say we respect those exclusive representation agreements. We don't tell people how to get out of them. We don't say, hey, here, let me see that. Oh, I can beat that price, right? And so why don't you cancel with them and sign with me? Those are some of the issues that come up with that. So that's kind of what we saw last year, and we're kind of seeing similar stuff this year. Discipline, everybody always wants to know, what are we doing with these people? And this is almost impossible to see, and I apologize for that. But as always, what our goal is different than the Department of Commerce. They do a good job. And I'll respect them for what they do. But for us, we take it to a point of trying to move people in a positive direction. It isn't simply about harming people, kicking them out of our industry. There are some people that need to be removed from our industry, and we'll do that. But ultimately, a lot of them are just mistakes, right? We wanted to do the right thing. We got a little confused, and we're trying to redirect in a positive way. So most of what we do, a letter of reprimand is almost always going to happen. That is, you did something wrong and you should know it. So we're reprimanding you. But we almost always attach continuing education. This is continuing education section right here. So we're trying to educate you, move you in a positive direction. And then this section right here means fines. So we're almost always going to fine you something. It's going to have a little teeth to it. So it isn't merely that you're going to get education, you're going to have a little bit of a fine too. Now we've had a couple of cases that are required to go to the Commerce Department. That's that tiny sliver there. So if it's a matter of public trust, if we feel like you've done something that's discriminatory against somebody because of a protected class issue, or because you've stolen money, something along those lines, then we think we need to send it to Commerce because we think maybe your license shouldn't be there. Maybe you shouldn't be allowed to do this anymore. So we're reluctant to do that, but in certain situations, we feel like that's what our obligation is. So we did that on 2 occasions last year. And one of those occasions was a situation in which somebody, I think honestly, had a good intent when he started this, but what he did was he took a lending letter, realizing that an FHA loan was going to have no chance in this multiple offer situation, said 10% down conventional, changed it and gave it to the listing agent, and that one won. And then when it was determined that it was never 10% conventional ever, he obviously, he falsified documents, right? He created a false document. And he said, well, look, my client had no chance without doing this. Appreciate that notion, but you can't lie, right? That's completely beyond the pale. That's way too far. So yeah, I mean, that one had to go to Commerce. We needed to make sure that that was a situation where maybe you shouldn't be doing this. Again, I understand what his intent was. He wanted to help his clients, but you can't do it in a false way. You can't create a false scenario that his client couldn't possibly fulfill. All right. And then this is just over time, and you can just see it's kind of standard. This is the most recent year, the dark gray is the most recent year. This is still what we try to do. Like I said, we really don't send a lot of cases to Commerce. That's not what we'd rather do. We want to redirect and possibly move things in a positive direction. Letter of warnings, I should say, happened on occasion. That's, you made a small slip up. Nobody really got hurt. No real problems happened. Just be more careful next time, right? Those are for those few cases. Most of them are going to have a letter of reprimand, a fine, and some kind of education. That's pretty typical. Citations are relatively new for us. We started citations, I want to say, in 2019. And citation was kind of meant to be a situation in which somebody could make a complaint about, let's say, an advertising issue, or one of those, hey, you showed up at the wrong time at the house kind of an issue. So it's pretty clearly defined. We think there's enough there. So here's going to be your fine. Here's going to be your education. Here's going to be your letter of reprimand. You can plead guilty, or you can say, no, I didn't do anything wrong. You can ask for a hearing. We were kind of hoping more people would just say, yep, I screwed up. This is my mistake. And so I'm going to go ahead and take it. Well, last year we had 15 citations that we issued. 9 of them said, I want a hearing. 5 of them accepted their citation. I will say of the 9 who accepted their hearing, there was one person who did a really good job. They came in and just almost wept over themselves. I feel so badly about this. It was terrible. It was a horrible mistake. I totally learned my lesson. I'm never going to do this again. And a little bit of the bleeding heart of the panel's like, we get it, we understand it. So they actually lowered what would be the fine that would normally have been done in the citation. A lot of people come in and go, you guys are off. This is just wrong. I didn't do anything wrong. I don't know why I'm here. This whole thing doesn't make sense. And almost every panel goes, you should have taken the citation because they're not bound by it anymore. So they hit them harder. Like, you need to know this was a mistake and you don't even think it was a mistake. It was obviously a mistake. So we're going to hit it even harder. We're going to make you do more education because we don't think you get it yet. We're going to make you pay a higher fine. So that message still isn't really getting out. More people are still requesting the hearing, even though they probably should take the citation because they're not really challenging the actual issue, right? They just don't think they should be disciplined for it. And so they come there kind of arrogant. That's not good. I wouldn't recommend it. But we've had some people, like I said, who really mea culpa all over themselves and literally in tears almost saying, I feel so badly. And that's worked. I mean, it has. You have, it's you guys that are the judges of it, right? And you get, I get it. I'm sorry. I recognize what might happen there. So it does happen. All right. Hearing panel appeals. We rarely have these, but now this year, all of a sudden we had a ton of appeals. Everybody didn't like our decisions. This isn't right. I don't think this is fair. And so they appealed, and 8 out of 9 times it was upheld. The one time it was overturned, I'll just throw it out. It's a little frustration for me. The person appealing this case won the original case. They were the complainant and they won. Okay, I want to emphasize that. They won, but they didn't like a decision that the panel chair made. And so filed a complaint saying the chair was unfair in this decision. It's like, but you won. So what happened was they won the appeal. They said, yep, the chair shouldn't have addressed it that way. They should have addressed it this way. And so they threw out the case so that it could be heard again. And I admit, secretly, I was almost hoping, I hope they lose this time. But that was not what happened. The justice was still done. They did the right thing and they found the right decision. And so we just had the hearing again. So it still had the same ultimate result, but there was one appeal that won, and it was over a decision where the prevailing party had already won. Anyway, all good. It happens. So our current issues, what we're seeing, like I said, the no inspection fears are kind of coming home to roost. We've had several of these complaints now. Where they're mostly on the list side, right? So we've had a couple of cases where we have had houses that have been empty for a while, and the listing agent is one going in and taking pictures. There's nothing wrong with posting selective pictures, right? You don't need to post every picture of every angle of every house. There's no suggestion of that. But in this particular one, they seem to really carefully miss some of the issues that were kind of obvious, like the ceiling that had, watermarks all over it, right? I mean, like clearly there's a roof problem because the ceiling had watermarks all over it. And this particular person who purchased it sight unseen, right? And so the listing agent, when we said, hey, you took these pictures, right? I mean, here's the angle of this picture. And then when he bought the house, this is the angle he took. Did you see the watermarks all the way up and down the line? No. Really? And when you're listing the house, you didn't see him there? No, had to have happened after I took the pictures. So within 30 days, that's when it happened, right? Well, maybe, okay. I mean, there was a lot of those kinds of situations where a particular agent had not disclosed what they knew because their seller had signed the waiver. Yep, your seller signed the waiver, but you're an expert and you can see the damage to the property. You know it's there. So you can't fail to disclose that yourself. Even though your client is doing the waiver, I have knowledge enough to know that's a problem. I have knowledge enough to know that although I don't know what type of mold it is, I know in the basement that the whole wall is speckled black to the ceiling. I mean, I know that. And I can't pretend I don't know that. I have to disclose, even if I don't know that it's mold, I need to disclose there's a problem in the basement. There's something you need to see. So we have seen a lot of those. A couple of the times they've gotten a little bit on listing on buyer's agents where there weren't multiple offer situations, where there weren't a ton of these issues, and they didn't at least suggest, I think you need to do an inspection of this property. It's old, you should do an inspection. They actually discouraged them from the inspection. When they said, I think I'd like an inspection, they said, no, you don't. This is the way the market's working right now. That's true generically, right? That this is the way the market was working, but it doesn't mean that every single property was that situation. There were definitely properties that weren't being in multiple offer situations that had been on the market for a long time. And they were only offering a waiver, right? Where they say, hey, in this situation, I think we should do an inspection. I think this is where we should protect you. And they didn't. And so that cost them a little bit there. So we are seeing some of those issues come up. Dishonesty in lending letters. Actually, that one case I talked about, we ended up having 3 of those cases. So, which is really discouraging, people falsifying those letters. And look, we're not talking about, hey, it was for this address and we just switched it to this address because the lender knows me and they don't care. I don't think anybody's worried about that, right? They still qualified. All those terms were still what they qualified for. That's not the issue. We're fine. But we are seeing, and some of it is just that problem. I've got a buyer that just isn't going to qualify for the easiest loan possible, and sellers aren't really necessarily being told that FHA isn't really going to be a problem for you in this particular house. So you should be willing to accept FHA, things like that. There are some of those problems that just exist for certain buyers, and I appreciate that, but we can't be altering those docs. And it's funny, we've had a couple of some of the listing agents who've picked up the phone and called the lender and said, I got this letter. Did you write this letter? And they generally say, yeah, I did. Not that they know that it was falsified, but they don't get clarity on, did they qualify for a 10% down conventional loan? Is that what they qualify? Because that's what it says. And if they would have asked that, the lender, I think, can say, sure. I mean, or no, they wasn't a conventional, they're FHA, and we're going to use the Minnesota Housing Authority money and things like that, right? And they didn't ask specific enough questions. So it's just something to be thoughtful about as the listing agent. I think it's perfectly fine to call. I think you should call on those letters. Hey, did you write this letter? Is this true? Are they qualified? Is this what they qualified for? I don't think they're going to get into a whole lot of detail, but I think if they wrote, this is what they're qualified for, or they can do it without selling their current home. I think you can ask that because it's on the letter. And I think that will tell you. If they say, I'm not going to tell you that, then, maybe it's something to discuss with your client. But we did see quite a bit of that. That was some of the things that are coming up. No realtor status ads on Craigslist. I kind of mentioned this before. We're seeing quite a bit of this. We have a lot of agents who constantly kind of go through those to see if they can get deals for the clients. It makes a lot of sense. It's a good farming opportunity to go through those. And they keep seeing these ads. And then they call on them and they go, well, are you a realtor? And they go, well, yeah. And they go, but you don't have anything listed here. And they're like, well, it's really my husband's company, or it's really my wife's company, or it's really something like this. And it's like, well, but aren't you going to be listing all these properties? Aren't you really, aren't you connected to this somehow? And then they really don't want to talk. So we've had quite a few of those. It's just not genuine advertising. You need to advertise. You great advertise, go ahead, but just say, hey, I'm a licensee, right? This is my brokerage. This is the minimum standard. So we're seeing quite a few of those. You guys had any coming soon issues? So I always say it this way too. Coming soon is really truly an MLS issue, right? So it's not exactly in our wheelhouse, but the issues that come from it are, right? If we're getting selective with it's coming soon and I'm showing certain people the property, you know, what we're seeing a lot of, we have a lot of crafty people out there who are contacting those agents saying, hey, is there anywhere to see that house yet? And they're saying, no, it's incoming soon. And then their client calls and says, hey, can I see that house? Or are you working with anybody? No, which is a lie. I don't think that's okay. I mean, that's not good. I don't think we should have people who are lying, but they say, yeah, I can get you into that house. So we're seeing some of that where it's not really incoming soon status. That's not so good. So we have people who are doing coming soon right, and people don't like it, right? You can make blind offers on a coming soon. There's nothing wrong with it. I can make an offer on any property, right? I don't have to, there's no problem with that. But there are some people who are abusing the coming soon situation. So we are seeing some of those complaints happen. And again, it comes down to an Article 3 issue, which is cooperation. We need to cooperate with each other. We need to make property available when it's supposed to be made available, when it's not supposed to be available. So
do you find those people that sell the house before it comes online, or what do you do with those people?
yeah, when those issues, we had that come up twice, and we they brought the complaint. The agent who, I didn't love the agent did this because he had his client kind of manipulate the situation in both situations. But yeah, then they filed a complaint and they said, well, yeah, we made a mistake. I mean, ultimately they ended up saying we made a mistake. It was just an
I've seen that
oversight.
4 or 5 times now that we're gonna go show the house and it's sold before it comes online.
And that happens quite a bit. And some of that is genuine, some of that is okay. It can be done that way, but a lot of times it's being done pushing everybody else aside, which ultimately is an Article 1 issue too, because how can that be in my client's best interest? How can it be not in my client's best interest to put it out there for everybody? Right? I mean, I really need to do that. That's really what should drive the competition and the price. So it's a problem. It's a worry. It's a worry, but it also is one of the market situations that we have, which is people are desperate enough to make blind offers quite a bit. It's happening quite a bit. Escalation clauses, and I almost don't want to deal with these anymore. I don't know if you guys are seeing this a ton. I bet you are, right? It's a lot. They're legal and ethical. They're functional. They work. Sometimes they're very effective. I also know that there are sellers who are horrified by them. They freak them out and they don't want to deal with them, and that's fine, right? I always think it's important to recognize my client does not have to play that negotiation tactic. If I'm a listing contractor or a listing agent, my client goes, this makes me uncomfortable. You can say, well, that's fine. You don't need to do that. Generally, they've given you their top dollar, right? Generally, they've said, we're willing to go this high. So you don't have to play that game. You can counter right back and just say, well, I don't need to show you any other offers. I'm just going to counter back at what your top dollar is. That's okay. You don't have to play that game, but it is legal. It is ethical. I always want to say it's important that there needs to be at least one more document put together that gives you a final price, right? I mean, every lender and every title company is going to want to see, hey, we at least need an addendum, or if you've already signed it, an amendment that says this is the final price. Otherwise, it's going to be too confusing to know what happened. The other thing is everybody always wants to know, can I send the highest offer that I got to them? Is that okay? Yeah. I mean, with one exception. Yeah. I mean, if somebody sends me an offer from another brokerage, I could post it on the internet if I wanted to. I have no duties of confidentiality to them. I do to my seller client. If my seller client doesn't want me to, then that'd be a problem. But generally they'd say, sure, I don't care, because now I'll get a better offer. The one caveat is when that highest offer is also an in-house offer. And that has created a problem for several people. How do I tell them this was an offer I got when it was from my buyer? I would need my buyer's permission to share that with somebody else. And why would I want to give that permission if I'm a buyer? It just means I'm going to lose the house. So I'm not too interested in that. People have said, well, what if I redact it? It's still their offer. It's still their information. You really can't. There's no redaction significant enough to do that. So that's the one hiccup. that I see in it is I can't share that highest offer so that you can, go $1,000 over it if it's my client's offer, if it's my buyer client's offer. That would be the one hiccup. Again, if they get permission, then it's okay, but I just don't know why they would. That would be a poor decision on their part. So escalation clauses work generally. And again, I probably should have started over with this. I don't know if you have any questions, but this notion of my offer is going to be $1,000 better than, and it doesn't have to be 1,000, but whatever number better than your highest offer. And then we see a lot of dueling escalation clauses, right? So, or even trying escalation clauses. I've got 3 escalation clauses. Do they piggyback on each other? Well, yeah, I mean, they do, right? So you can go right to the top dollar because you've got offers that are bouncing back and forth like a pinball machine, right? So they're working, it's okay, but we're seeing some of the fallout. Article 16 questions, we have seen an uptick in abusing those exclusive representation agreements that people have. We've seen some very bold stuff with regard to that. As I mentioned before, it happens a lot. People will call you and say, hey, I'm listed, but I'm not liking what's going on. What can you do for me? And it is okay for you to discuss what services you provide, the price ranges that you provide. All of those things are perfectly fine to discuss because they contacted you. What you can't do is say, well, what are they charging you? I'll beat that. What you can't do is say, you're with a lesser substandard carrier. If you come to me, we're a first service kind of group and we'll treat you better. We'll make sure it gets sold, those kinds of things. You just have to leave whatever they're currently under. When they say, how do I get out of this contract? You send them to the broker, their current broker. Well, you talk to your current broker. Don't tell them talk to an attorney. Don't tell them this is how you do it. You send an email. We actually had somebody who drafted the email for them. This is what you write to the broker to get out of it. And it was so interesting because the clients were English second language type people. And this was drafted in a professional language type of email. It wasn't like anything else. So when the person got it, they're like, who's this coming from? Because I've had several conversations with these clients, and this is not the way they speak. This is not at all their tenor or tone. So we've seen quite a few of those situations come up. And we've seen some interference issues that have happened. Yeah. Well, so what has changed under the code last year? This is a one that we're dealing with quite a bit now. We don't have great direction on this because we don't have any case studies from national on this yet. But because of the lawsuits that have been coming out and issues related to antitrust, we made a deal with the Department of Justice, I guess, the National Department of Justice, that we would change a lot of what we say. So we are now moving away from the language of free or no cost for anything that we have an expectation of getting paid on. So what everybody has been asking me is, well, if I do a market analysis for somebody to try to engage them as my client and I do it for free, I should be able to say I'm doing it for free. I'm going to give you a market analysis. There's no strings attached. Here it is. You can agree to list with me or not. Aren't I okay still? Can I still say I'll do that for free? And to a degree, the jury's still out. I think so. To me, I think if you got a panel of 5 realtors on a board and somebody brought that complaint that said you did free, you gave it to me for free, but then you asked me to sign with you. And so I signed with you. And so I eventually paid you. I don't have a problem with that. I really don't. And I don't think most realtors sitting here would say, yeah, that's a problem. I think most of them would say, yeah, you're marketing. That's a marketing tactic. And you gave it for free and you would have let them leave and sign with somebody else eventually because you weren't binding them in any way to this. There was no catch. There was no hook. It was just simply like me giving you a business card or me giving you the list of things that we do for you that made you think, yeah, this is somebody I want to work with. So I don't think that's a problem. And I don't think you'd have 5 panelists, but I'm a little worried that we're going to get a case study coming from national that's going to say, no, you can't even do that. That if there's an expectation that you're going to get paid or an expectation that you're going to be compensated on some level, then you can't use it. And the reason I don't like that is every time I do this, I won't really have that expectation, right? I do market analysis for tons of people and I hand them out to people and I'm hoping they're going to sign with me, just like when I give them a business card, I'm hoping they're going to come to me and call me, right? But I don't have an expectation or a reasonable expectation that means they're going to sign, right? I think it's still a marketing tactic. And I think I'm willing to give you this marketing research, this market research so that you have it. It's yours. No strings attached. But when you want to sell your house, I'd love it if you come to me so that I can help you with this. I think you're not going to have 5. I know right now you would not get 5 panelists who would say that's wrong. Nobody's going to say because you marketed that I'll give you a free market analysis and you hoped that they would sign with you, did that violate 12? But the jury's still out and I'm worried about it. It's out there. We're supposed to move away from the language of free or available at no cost kind of a situation. And people are getting funny because they're like, well, what if we use the Spanish words? Or what if we use, I can't even think of what the Latin lingo is, whatever it is. I'm like, yeah, it's not, they're not being put in quotation marks there. They're trying to get a sense that we're trying not to tell people that everything is free. I think the whole point of this ever was don't tell buyers that I'm doing this for free, right? When you're not literally doing it for free. That was what the whole intent of this whole article was for, this whole standard of practice. And I agree with that, right? You should say, look, I'm hoping to get paid from the listing side, but if I don't get paid from the listing side, this is what I expect to be covered. And you could make that free, or you could say 0. I'm not going to take anything from you, but you would need to disclose how you're getting paid and why. But this is moving it in a direction that I don't love. I don't think it's necessary, but it was something that was put upon us by the Department of Justice. So we'll see. It's to come. And then this is last year now, but I still cover it. Policy Statement 29, Standard of Practice 10-5. We moved on Policy Statement 29. It used to say that all of our real estate related activities were covered under the Code of Ethics. And now we simply say all activities, respect to all activities. Now I say this, and it generally freaks everybody out, but I want to make it clear that it still does to be, even though it's all our activities, it still needs to be connected to the code, right? So I have noted that if I were to have said to somebody, my son played a baseball game last night, they won, closed it out. I'm kind of proud. He closed it out, it's good. Last 2 innings, it was a 1-run lead, and then they scored 8 runs in the next half. So he didn't exactly get a save with a 9-run lead, but he didn't give up a run. So, okay, so if I embellish that a little bit, if I describe to you, hey, he got the save, bases loaded, and he had 3-2 count and he threw a strike right down the middle, and somebody was there and said, hey, I was there. He had a 9-run cushion, and there was a really weak team that was playing, and this guy swung at the ball for sure. I didn't break the code of ethics, right? I didn't break the code of ethics. I may have lied. I may have lied intentionally. I may have said something that was silly, but it wasn't related to a transaction that was happening. Okay, it wasn't related. It wasn't trying to induce anybody into a contract. It had nothing to do with anything. So it's not still going to apply. Okay, it still has to apply in the sense that it connects yourself to the business of real estate. Okay, so again, on Facebook, if I say something like, I got a 32 on my ACT, which would be, boy, my kids are all taking the ACT lately and they've just laughed at me. It's terrible. It's embarrassing. I obviously married up because the brain pool got much deeper because of my wife. But if I said, no, kids, I got a 32, or I posted it on the internet, right? Again, that's nothing to do with this. It's nothing to do with somebody's transaction. It has nothing to do with inducement to sell. It's just a lie. I shouldn't do it. That's bad. But it's not connected in any way. But what we did see in the aftermath of a lot of the civil unrest in 2020 was a lot of postings that were really embarrassing. And it was embarrassing for the realtor brand that connected to that in any way, shape, or form, right? So there was a sense of, hey, we need to step in and move into this and say, look, you can have political discourse, that's fine, but we need to be careful about our language. We're not going to use any slurs or epithets based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So that's the change that actually happened in terms of the language. And that's the standard of practice that we're dealing with. No harassing speech, hate speech, epithets, and slurs based on those protected classes. So again, hearing panels should be clear that the standard of practice is narrowly conducted. It has to be connected to the actual article. So no one's ever found a violation of a standard of practice. Okay. So we talk about, for instance, 3-9 is that duty to make sure that we don't provide access to property on terms other than those of the listing broker or agent. No one's ever in violation of 3-9, they're in violation of Article 3. Similarly with Article 10, there needs to be some basis to say, okay, this statement that you made, whether it was verbally made or whether it was made online, then would cause someone to think that they're being discriminated against on one of those bases. So it really is going up to that actual article itself. So I'm grateful. We've had a few of these cases. We haven't had a ton. I'm glad of that. I don't want to have a ton of these cases. I hope that there aren't a lot of these cases, but we're prepared to handle them when they come in. This is kind of giving you the case interpretations that they've come up with, have kind of described what some of this might mean in terms of hate speech online. There were seen also verbal comments. It doesn't necessarily have to be something that's written. But the one that's come out lately, this past year, I think it's enough for all of us to think about. And this one I think will be the most challenging potentially. So in this particular case study, they said somebody who had a listing, a new listing, and they'd hired a photographer to take pictures. And they took pictures, and in one of these pictures prominently displayed is a Confederate flag. So I assume it's like, for instance, let's say a den. They took a picture of a den, and it's clear that you can see a Confederate flag in the corner of the den. This agent who kind of readily does this, hires this photographer, generally just picks 15 photos and uploads them to the MLS. So the listing agent didn't upload them to the MLS. A person reviewing these photos saw the flag, was initially interested for their client and themselves to review this, but felt, okay, my client isn't going to be welcomed in this particular property. So filed a complaint against the agent, saying you uploaded this image, it had this hate symbol in it, and therefore you discriminated against both me and my client in terms of being able to see it. And they determined that's a violation of the code, even though the guy said, look, I don't know why the flag was there. I don't believe that. I don't have anything to say about that. It was just an accident. I just uploaded it. But nevertheless, the agent was found in violation on that basis. That's a little bit intimidating, right? That is not me making any statements. That's not me projecting anything. It's me posting something in a picture that I didn't look very clearly at on the MLS, and it was determined to be a violation. So we'll see how that one flies out. I was at National when we had this, and I said, okay, so the Confederate flag is a symbol of hate. And they said, yes, it clearly is. And I said, okay, can you give me the list of hate symbols then? Because we want to know what those definitively are. And they said, no, you know them when you see them. And I go, well, that's helpful. I struggle with this. I'm that guy who struggles. What is going to be a symbol of hate for whom and how? And how are we to determine what that is? Please give us that guidance. And they didn't want that.
And what would happen if they didn't post that and then they walked in and saw it?
Saw the flag. That was one of the questions that was, wouldn't you rather know that it was there?
Right.
And I said, look, what if he's a Civil War buff? There are plenty of those, and they have all kinds of stuff. What if you're a World War II buff? And so you have Nazi paraphernalia. I'm not a Nazi, but gosh, I love World War II. And so I've got Japanese flags and American flags and British flags, and I've got Nazi flags. I've got all stuff. What is it? How do we make that determination? And they said, it doesn't matter. So that's where we are. So it's a bit of a challenge. I admit to being worried about it. I don't know exactly how that'll fly, but again, what'll happen is it'll be a panel of you guys who will make that determination. You'll be able to have that information. You'll have a hearing. This person may be able to come in and say, look, I'm a World War II buff. This is why I have this stuff here. I'm a Civil War buff. This is why this stuff is there. It wasn't intended to be any kind of discrimination. And then a panel will make a determination as to whether or not it was. So, but it's there. It's something new. Yeah.
I'm on the Risk Management Issues Committee for NAR.
Yeah.
And some of the terms that they came up with that could be racially offensive, Jack and Jill bathroom, mother-in-law suite. I was like, where does it end? How do we
Right.
know we're being offensive? And of course, it starts with master bedroom,
Right.
which is still on the MLS. It's interesting.
Right. Well, it's something that's going to get hashed out eventually. But again, I think a lot of it, and again, ultimately, it'll be a panel, right? A panel will sit down and say, well, look, that was not your intent. There was no, this is, I could see where this person could have this sense of this, but we don't think that's a violation. And ultimately, it'll still be panelists making the call, member realtors. But it is a challenge. That one was a newer one that was a bit more concerning, probably. All right, I'm happy to take questions. That's all I got. Yeah.
I want to clarify, let's say I've got a multiple offer situation. And an agent calls and says, what's the best offer you got? And I tell them it's 400,000 conventional. That's an ethical response?
So in that, if it didn't come from your client, Yeah, I mean, if your seller client wishes you to, right? I mean, you'd want to make sure you're clear with the seller client. But yes, right, if your seller client said, sure, see if you can beat that, go ahead and tell them what the highest offer is. Yes. Now, I worry about there being a concern that I work duplicitously in that, right? So if I have a buyer client that wants the same house and more multiple offers, and I just say to my buyer client, hey, this is the top offer. Let's see if we can beat that. You can beat this. Can you beat this? Then I think you've got some unfair dealing happening, right? I'm not treating everybody the same, but I think if I'm treating everybody the same, I'm generally okay, right? So if one person calls and says, what's the top dollar? I think you can definitely say, this is the top dollar that we have with my client's permission. This is what we've been given. But I would give that information to everybody. Does that make sense?
Would you publish it then? So,
You could.
I mean, would you be obligated to publish it then? One person asked, you tell them you got 8 offers. Should you then go to all those 8 offers and say, here's what I've got?
So the short answer is, I think so, right? I think that A is best for your client. I would say then I'm giving everybody the same information. I'm treating everybody the same, and everybody now having this information will give me the best offers for you. So I think that's the best way to do it. When we're selective about it, the risk runs of somebody saying there's a reason behind your being selective. And maybe it's a nefarious reason in terms of a protected class. Maybe it's a nefarious reason because of I benefit from it in terms of monetarily because it's from my own client. So I would suggest it's best to do it in a public manner. Publish it. I mean, I don't think you have to put it on the internet, but I think if you sent a text or email to all of them saying we're at highest and this is our best offer right now, can anybody beat it? I don't think that's a problem. I think you're able to do that. Again, especially if it's not your client who made that top dollar offer.
But what if they're not all equal? Maybe only 2 have no inspection.
Always.
I mean, I think for me, when I do it,
Right.
2 rise to the top.
Yeah.
And it's like, all right, if they can,
Mhm.
you're protecting your seller. I'm not gonna say take an FHA.
Right.
Whatever.
Right, no,
Don't get me wrong. I just use that for
right,
example.
100% cash
But I mean,
offer that's
all the
5,000 less
offers
than the
are not-
FHA.
You know, some could say they don't wanna close, closing date, there's other factors, but
Right,
I typically will say, okay, these are what you want for close date, blah, blah, And then
And
I would
that's
go
all-
back, but
Yeah,
it's
just
not
the
all
price.
equal. I mean,
Yeah,
to me,
but it's
that
not just the
like,
price. So you-
now where do we go? I mean, you
Yeah.
gotta thin it out, right? You could be there all day.
and I get calls from angry buyers all the time to say, I see what they sold it for. I was offering $1,000 more. They had to take my offer. And I'll say, no, they didn't. Well, they have to take the top dollar. Why? Why do they have to take, why wouldn't they? Well, I can give you 1,000 reasons why they might want to take it. I mean, it's not simply dollar. You're right, 100%. It doesn't, you can make those decisions and your client has a lot of different needs depending on the client. So,
I have a couple questions. There's a lawsuit filed in Iowa a year or so ago. It's supposed to go to the Supreme Court this year. What happened is the buyer got out of a car. It was snowing. The people had already moved out of the house, so the driveway wasn't clean. They slipped and fell, and now they're suing the listing agent and the buyer's agent. Have you heard anything about that?
I have not heard that one. I know the council in Iowa, so I should probably reach out to them. There are those issues that come up. The listing agent, I think it's harder unless I've made some sort of agreement that I'm going to care for the property, right? So you could set up a situation in a listing that says, look, you're out of the house. I'm going to make sure that it, it's shoveled and clear and everything like that. Generically, it's not your duty, generically. So I would say that's a tougher one to make on the listing side. On the buy side, even harder. I'm showing up at a property that all I've seen are the pictures and the information on there. And I expect that I'm going to be in a safe environment when I go. So I think it's harder to say I should have advised my client to wear, different shoes or to be cautious. I mean, there could be variances there. I mean, the way I look at it is probably going to be homeowners insurance. So ultimately the homeowner is the one that's going to be responsible. I realize it's the deep pockets, right? Everybody wants to go to the pocket. So they think you've got good E&O, so I'm going to go after you. So they're going to bring everybody into the pool. I appreciate that. But from my perspective, from Minnesota perspective, I really do think that the homeowner is going to be on the hook for that one. It's going to be harder to make the listing agent on the hook unless he's formally agreed, I'm going to clear off things for you and care for the house. Sometimes that happens. Sometimes listing agents will say, I know you're in Florida for winter, so I'll make sure that it's all ready to go for showings. Then I do think you've added that liability to yourself if you didn't provide that. But generically, I don't think that's an obligation. Is that helpful? I don't know if it's helpful or not. I'll look it up. I'll see what I can
I'd be
find.
interested in.
I'm curious to know what will happen there. Yeah.
And when there's a complaint, somebody files a complaint with you guys.
Mhm.
You don't tell them who filed the complaint and really what the complaint is.
Us?
Yeah,
No, we'll send you a copy of the complaint.
had a complaint filed against me and I never got a copy of the complaint.
You didn't?
Nope. I knew what the complaint was because I knew the house what was going on, but I still didn't get anything formal from you guys. And then he lost that and went to Department of Commerce and they did the same thing. Well, we can't tell you what the complaint is or who filed it.
Oh.
And that bothered me more than anything. And I
Well, reach out to us because
Okay.
literally our process is when we get a complaint, we send it to the broker and the agent. The actual complaint, you get a copy of it.
Right.
So you get to see literally what we have. And then everything they submit to us,
Mhm.
we give you a copy of it. Everything you submit to
I
us.
did get that, you know, once all that was submitted, I did get that, but I was never told who filed the complaint.
But it says on the complaint, like, we don't accept anonymous complaints. Like,
So I didn't, okay, that's fine. but-
I mean,
Yeah, I understand.
like when we get them, if somebody, we've got people that are funny and they'll put, Daffy Duck and they'll put
Sure.
123 Main Street, we throw it away.
Mhm.
Because we're not gonna do that.
Okay.
You have to tell us who you are, and I mean, the whole thing is intended to be total transparency.
Well, I thought so too, but I didn't,
Okay.
I was
Well-
surprised.
If it happens, and I apologize, it's possible that it was sent or lost or something like that, but please reach out to us, because we'll get it to you right away. I want you to have it as soon as possible.
Yeah.
Yeah, that's what.
Department of Commerce did the same thing.
Commerce does that,
They do that. Yeah, they do.
which I think is completely unfair.
Okay,
How do I know how to defend myself if I don't know what the issue is and who brought it?
exactly.
That's completely unfair. So it's a hallmark of due process for us, so.
Okay.
But please, if that were ever to happen again, please just reach out to us and say, I didn't get it, and we'll make sure you get it, absolutely. Question?
So there's been discussion about the co-op commission being variable to the buyer's agent based on commissions they've offered over the past year. So if somebody's offering 0 or substandard co-op commission, then in the MLS line, it would say where anybody that's offered less than X percentage is going to get that percentage as their co-op commission. Have you heard about that? Seen that?
No,
Tell me what your thoughts are on it.
I'm not a big fan of that. My worry ultimately is that I feel like it's a worry of antitrust. So if there's a sense of a standard, any sense of a standard commission payout on the co-op side, always rattles me, because I feel like that's right where Commerce or Department of Justice will come in and say, see, you've just got a co-opted system. It's all wink, wink. Everybody knows what the actual price is. And so you've colluded together to set a standard price without disclosing it. So when I have people who call up, I have it all the time and say, they're only offering this rather than what I say is the standard. And I'll say, well, thank them, write them a thank you note, because they're saving us from any type of standard price, right? They're actually doing us a favor by making a variance in that commission, in that what we call standard commission, because we don't have a standard commission, right? So they can offer whatever they want and they do. So I don't love that. I don't want to see too many variances. I mean, I'm okay with the notion that there are two fields, right? A buyer rep gets paid this and a facilitator gets this. I'm okay with that because technically different types of fields, different types of expectations of the work necessarily to provide there. So I'm okay with that. I'm also okay with saying I'm going to pay either one the same amount. That's okay, whatever they want to do. I worry about the proofs that would be needed to be happen to say you get this unless you do only this, unless you do only that. It's going to create a lot of different standards of proof of what needs to be done to achieve each bar. So there'll be more concern, more confusion, more cases. I guess that's good for me. I like the cases, they're interesting. But that makes me a little nervous. I would rather it be the less parameters around what you need to do to get paid, generally the better. Doesn't mean the less work, there's gonna be a lot of work involved in it, but the parameters, just whatever those are. Is that right? Am I making sense or am I missing the?
You are, and kind of, I guess, as a listing agent, they always pay out X percentage. I'm just trying to be vague.
Yeah.
But then as a buyer's agent, they get a higher commission split because that's what the agents pay.
Right.
So then the argument is that somebody puts in there, well, if you always pay out this percentage, that's going to be your percentage as a buyer's agent.
Right. Yeah, and I don't want that. I don't like that kind of discussion. I find that discussion to be troubling and concerning. And we've seen some of it too, more of it out greater Minnesota, where they feel like we all have this sort of agreement. We'll put this amount on the MLS so that if somebody from another association makes an offer, that's what they're getting. But we all have this agreement that we pay, 2 percentage points more.
Wow, that's interesting, because I just looked up some in the county north of here, and they were all real low, and I went, whoa.
I've been more than vocal that that's specifically an antitrust issue, and if it were true, that's only rumors that I hear. If it were true, that we would have serious problems right away, serious problems. So it's a worry that I've had.
Before you move on from this topic, we've got a comment from online that says the DOJ is actively investigating and asking questions about the Minnesota MLS.
Okay, I didn't know that. Okay, lessons learned every day. It's good to know. All right, yeah.
On the inspection deadline, first of all, I guess I don't like the way we've changed the inspection process.
Okay.
Because I thought that the way we did it previously worked better. But the way it is now, I had a situation where an agent coming up against the deadline lost his phone, and it was the buyer's agent wasn't able to get a hold of him before the midnight deadline and was pissed. And so was that an ethical violation? He claimed it was an ethical violation on my agent's part because he wasn't available to communicate with in the final hours of the before the end.
Well, I mean, it's not an ethical issue unless he's lying. If he lied and said I couldn't find my phone, wink, wink, nudge, nudge, I saw every call coming in, but then that would be a problem. But no, I mean, he would still have had the ability to send an email saying we're canceling. If you're not getting back to us, we're canceling. And that's all he would need to do would be to provide that written notice of cancellation prior to the expiration, and then he would have been fine regardless of.
Does it have to be a written notice?
It does need to be in writing. So I get it. I mean, and the reason that is I wasn't on the committee at the time, but you're talking about you have this many days for an inspection and then you have this many days to negotiate. And if you're still negotiating at the end, then it cancels if you haven't reached an agreement.
You've only got that one period.
And now
do your whole.
And now the whole thing is just one period. Right. And
But before, the difference is, in my mind, is before it was, I don't know, there was, I don't know, I don't remember how the language changed, but it kind of flipped the situation.
Mhm.
Right now, the buyer has almost no leverage in that situation.
Right. Well, other than to just cancel. Right. I mean, I agree with you.
Right.
Yeah.
I mean, he's got to go all the way to walking away.
Yeah, I mean, I agree. And I think a lot of it is, but I mean, it's always been that way. That's really their leverage, is to say I'm canceling. But yeah, especially in this market, I think there's a weak opportunity for buyers for sure. Yeah.
Have you seen in Minnesota, I've heard of this happening in other states where agents will pay a seller to sign a listing contract with them, saying that if anytime in the next 20 years, you'll use that agent, but then the sellers kind of forget that they signed that and it's recorded at the county on the deed. And so then another listing agent comes in to list like 10 years later because the sellers have forgotten about it. And then that first agent comes back and gets the commission because they have this recorded.
Wow. No, that's new on me. That's scary. I don't like that. There is no statutory limitation on the amount of time you have. You just need to have a defined end date, start date and end date. I think there's something that's really
And can
concerning
you
about a notion of a
pay,
20-year.
Yeah, can you pay a seller to sign a listing contract with you? Is that ethical or legal? I guess.
It's not specifically unethical or illegal. It's generally not needed. But it could be done. I worry about there's a little bit of a shock to conscience kind of a situation there. I wonder how enforceable the contract ultimately would be if push came to shove with a judge who said, he said, well, it could be. If it's a nominal fee, if it's, I'm paying you $100 and this is how we're gonna do it, I think that's gonna be a harder sell. But I mean, if you could say, look, I gave him $5,000 and the term was that he's gonna have a listing agreement with me over 20 years because of that, maybe. I haven't seen that. That's interesting. I don't know.
Who would sign
My
my ex?
Contracts have to have compensation.
Okay.
That's concerning. I don't like that at all.
Yeah.
Yeah, go ahead.
Doesn't a contract have to have compensation?
Yeah,
So you,
right. Well, that's what she's saying. You get $5,000 or $1,000 or whatever, that's the compensation. And the agreement is that if you agree to sell, it's kind of a right of first refusal in a way.
Yeah,
and isn't there also a rule that says that you can't, let's say you get a listing I thought there specifically was a deal. If you get you can't say, I'll list for this much if you give me the buy side also. You can't, I don't think you can contingent another transaction on.
There's
the
not
first
anything in
one.
the statute that disallows that. So I know there,
That, if they buy through us, I'll give them a break.
right, there are quite a few who,
It's really always, but I do that. every
yeah, there are quite a few who do that, who say, if you buy through me, then this is what this is the
Especially if
percent
they're
I'll
not a shake
charge you
buyers.
on the list, side,
Yeah.
which is different than what I would charge somebody else. I mean, generally speaking, it's okay. Yeah. Good. So far, so good. Any questions or otherwise? Guys, that work for you. So if you have questions, call me. I'm happy to discuss them with you. If you're interested in working in pro standards, I always toss this out. It sounds like something you'd be kind of interested in. Please let me know. We're going to start applications coming up for 2023, coming up in July, probably July 15th, they'll start coming out. So if you have questions about it, it's fun. You learn a lot. There's not a lot of, right? It's not bad, is it?
It's awesome.
Yeah, I mean, it's fun. You get to learn from other people's mistakes. I think that's the best. It's a great education, right? You get to
It
see.
doesn't take that long.
No, there's one training a year and then you serve at your leisure. So we'll
John
reach out
makes
to you,
it
say, can you do
entertaining.
this? And it's hard even to get people.
Because I'm on that. I think I've only been on one case
Is that right?
last year, yeah.
Okay, yeah.
So.
It
want more.
depends on conflicts.
Yeah, I
Well,
know.
that's happening.
I'm like, maybe I did something wrong.
No,
I was
if-
thinking the same thing.
Well, what people will find, like you might serve on a bunch of grievance calls, but because we have so many fewer cases that go to actual hearing, getting them into hearings is harder because we only have 5. So that's a little bit. Yeah.
You don't want to.
So, but so think about it, let me know. Otherwise, I appreciate your time and call me if you guys have questions, emails, happy to take. Appreciate it.
Thank
Thanks
you,
everybody
John.
online. Good seeing you.